Secretary of State.
You sure you have enough
Yeah,
titles?
exactly. But really, I come out of counsel's office and
You're a
Executive.
lawyer.
Yeah.
Yes. Now we had a. We're on. Oh, great. There was a woman
Hello.
that was a lawyer. Was she your predecessor? She'd gone to Virginia. That's
yes, Nina DeSalvo.
Yes.
Oh, I think it's
Moved on.
Yeah, she's out in Colorado.
Oh.
She wasn't a member of our committee, but she was.
Frank,
Yes.
can you hear us?
morning.
We just
How
want to
are
make sure you can hear
Good
us.
morning.
Hello, good morning.
We were a little nervous that we weren't going to connect up with you.
Well, we have connected.
goodbye.
Is Dave coming? Is Dave coming?
Dave will be at the meeting, and he says he has to leave at 11. So I was suggesting earlier that our areas of disagreement seem to be relatively minimal, and maybe this can be a 1-hour meeting.
Sounds fine to me. I have, I didn't get a chance to read this until last night, and I think it's good. I have some comments. No, they're not substantive. They're places where I think we could use opening statements or topic sentences. But shall we start? Is it 10? Do we have a quorum?
We don't have a quorum yet, but I'm hoping that we will within a minute or two. Hope so.
Oh, we see it on the screen now, Rhonda.
There's just nobody there.
No, I don't see
There's a
anybody.
note coming through the door.
You say you think he will?
Okay.
I think he will.
Oh, yeah.
Yes, he will. He's been doing this for longer than
And this is
you
your
and I
usual
have.
room, right?
Yes. And I'm going to talk.
Changes to a draft.
Yeah, we can, but I'm guessing we will have a quorum within a very few minutes.
Mm-hmm.
And
Thank you, Rhonda. All right, bye-bye.
that's Buffalo?
Buffalo, yeah.
We can approve,
What the hell?
we can approve a report on the, based on last minute drafts, right? Isn't that what we've done in the past?
Sort of, but again, let's just give it a few minutes. I'm hoping to see Amy from Budget, and we'll see who's in Buffalo, and I would expect that Dave Schultz is going to walk in any moment.
Okay.
I hope so.
I was trying to avoid a third meeting if we can.
Yeah.
Not that it isn't fun to see you all.
Yeah,
On
it is
TV.
fun.
On TV. See, I'm now meeting Jim in person for the first time. Come in.
Yes, face to face.
This might be him.
I hope so.
Did we lock? Did we lock you out? I'm sorry. The TV came on and it seemed very loud.
Sorry.
Jim is came.
I'm getting so fed up with the news. Sorry. Something went on that shouldn't be. The subways, it took me forever to get downtown.
From your office?
Well, I actually was leaving from home this morning because my office is now on the east side and it doesn't make sense to. Anyway.
No, the
Morning, Dave.
subways are
So
not
what do we do
good.
about Buffalo here?
Where's the beyond?
So there's nobody there.
Nobody's there.
Here's Amy. We have our quorum.
Yay!
Thank goodness.
Yay.
Actually, we want you for your personality, not the fact that you make the quorum.
That was a good line.
I think it's good. All of us. I'm gonna
That's good.
close.
Here's my moment.
We'll see.
Yeah, apparently it locks automatically.
Oh, well, if we annoy them, they will come close this door. I think they've done that before.
All the members of the public, I'm sure.
Yes.
Usually attend.
Yes. Well, we've had a few members
That's
of
what I
the.
mean. That's why I don't want to
We've
close
had
it
a-
because it'll lock.
We've
So you
had
never
a
know.
few, but. Well, should we dispense with the minutes?
We could dispense. We could do whatever you want with the minutes. I think they're pretty minimal.
Yeah. Does anyone have any objections to them as written?
Good.
we can either deem them approved, or as you are always telling us, we don't even need to approve them.
Well, I think we can deem them approved.
Well, deem them
And-
approved.
Okay, we have
Worst things
6.
have
We're
been
good.
deemed.
We're good so far. Just an initial note, we have 6 people, which is our bare quorum. And Dave, you still have to leave at 11?
We're going to be out of here.
Okay.
I
If
can
our chair
take-
says we're going to be out of here by 11, we will be.
We were all pretty close.
You know what? I think it needs more topic sentences than leads in, as I read it last night. But,
Before we begin, I just want to thank all of you who submitted your comments. It's greatly appreciated when I find out that people actually read the report and think about it. And after all, it is your report. What I've tried to do is look at it. I told Bill Brusso and Dave, you didn't hear this. I tried to incorporate your comments on a draft in blue and Bill's in red so that we could go through this in a reasonably efficient way.
I haven't seen yours, Dave.
Yeah, print it out. This is what David sent.
I didn't,
Go on,
I didn't, I missed Dave somehow.
I'm going to just scan
Okay,
through because I did
yeah.
it in color so you can see the red.
Oh, okay.
Is the one that's in the packet, mine doesn't seem to have any edits.
What, I somehow missed Dave's. When did you send yours?
Friday afternoon.
I am,
Yeah, it doesn't incorporate it.
I am,
This one must be older. What's in our
Yeah.
packet?
yeah, the one in our packet is older. Well, you know what, my comments are more general, and they probably, as often is the case, have been fixed by Dave's comments. I am technology challenged, living in a rental apartment with no computer and no printer. So I went and
Wow.
printed off. I went and printed off yesterday, and
So that has
Is it both?
yours,
Can I just
and
look?
then this one has
So this is
Bill
mine.
Brusso's.
Russo and Walker. I got both of those, but
Yeah.
Waters. But I didn't get.
Okay.
Well, we'll start on page 3.
I think we should start on, page 3.
All right.
The
Which
cover
is-
letter had a change.
This should be renumbered, page 1.
Yeah, should be renumbered. I thought, and Dave's edits may have fixed this. I thought we needed a stronger overall opening statement about the year, the good and the bad. Only needs to be 2 sentences, but instead of just leaping right into meeting the burden of proof. So I'm happy to work on helping to write that, and it may be that Dave's edits to the first paragraph address that, but just,
I had actually put another note on mine, which I guess didn't get picked up because it wasn't an edit, that I didn't think the order, it makes no sense to me to just start with meeting the burden of proof. It made no sense kind of hanging there, like who's meeting it, what's meeting it, and it also seemed like a kind of weak point. I would maybe reorder them and start with one that seemed more important, but I can't remember. Didn't bring my markup.
Well, the suggestion was that we sort of kick off with what is positive.
Right,
And-
sealing the
yeah.
court records and the attorney's
we
fees, move
talked-
them to the top.
And we talked a little bit about the federal experience. There were some positives there, but my personal feeling, Dave, and I don't know if you would agree necessarily, is that the federal courts have fallen down in their interpretation of the Federal Act, whereas New York courts, in many instances, have been serious about the government's obligation to meet the burden of proof, which is sort of why I put it up front. But
I'm not
we can-
sure. I think it's a little bit of an overstatement. But I thought if we moved the sealing of court records and attorney's fees to the top of the list, that's really sort of patting them on the back for getting something done. And
Okay.
start out with a little introductory paragraph along the lines before the first heading, along the lines that our chairman was recommending, of just sort of saying something about here's some good developments and just an introduction to the list.
Do you have anything in particular in mind, Franklin?
no, but I can sit and write something, or we can lift the kind of language we've used in our prior reports. Just something that's a lead-in that explains that what we're doing is that 2017 has been a year of whatever improvements, but there's still troubles. And to set the context for this. I think in part I was troubled by what Dave just pointed out, that leading into the burden of proof just seemed abrupt and not all that strong.
All right. Is there, what order would you like so that we could just reformat this and more or less be done?
Start with sealing of court
Sealing.
records. So go A, B, down at the bottom, and then C, D, E. So go here. Sealing of court records would be A. Attorney fee legislation B. Meeting burden of proof C. Interest and knowledge D. Law school transcripts including exceeding.
Okay.
Okay, and then burden of proof would be the last.
All right. If we're going to do them in that order, and again, I apologize that my notes didn't come ahead of time. We need a little more context for the sealing of court records. We made a proposal to expand. Who did we make the proposal to? Who didn't adopt it?
We didn't make a proposal. We just commented on the proposal that was before the administrative board that makes the rules, and we checked on the rules and it didn't happen. So
and that's fine. I just think we need to say that because it wasn't clear to me who didn't adopt the proposal.
Okay.
So we just need to provide the context of where was this proposal made, and then we're pleased to report it wasn't adopted by the administrative board or whoever it was. It's just hanging.
Okay, we can do that easily enough. In the paragraph, meeting the burden of proof, there were a couple of suggested alterations by Bill Brusso and by Dave. Instead of saying unlike many jurisdictions, unlike some jurisdictions, across the United States was unnecessary. And there was a suggestion that the most exceptions be a new paragraph to make it flow better. There were, again, a very few changes, let's put it that way. And again, I can send them and assume that they'll be acceptable. In the passage involving interest in and knowledge,
I'm just trying to find.
Bill, were you comfortable with Dave's phrasing? You had a suggestion in enforcing agencies. Were you comfortable with what David said, or did you want to
I
argue?
think you could work both of them in.
You think you can put them both in?
I don't have.
I liked an enforcing.
Fine.
I didn't get your email on Friday. Oddly enough.
All right, so you can work them both in.
Yeah, our courts have been in.
And he circulated
He
something,
circulated
I think today or over the weekend. When did he send us around?
Friday.
I'm trying to find Dave's comments online.
I'll
When
send
did
him on-
you
I'll
send
him
them?
on Friday.
Yep.
From
Well, it would have been an email from Candace, maybe?
Yeah, late.
Yeah.
Oh, it's from Candace? That's what I missed.
So
I see Steve's, but I don't see.
Aren't they also in the folder?
Thank you,
They were in
thank
the
you.
folder.
They have a different,
Yeah, see, I saw Steve's. but I-
earlier version.
Yeah.
We have Peter Grimm. Peter Grimm has just joined us.
Oh, great.
And Gene Hill. Hello, Gene.
Hello, how are you?
So we do have our quorum. I was nervous.
Okay. While you're
Here they
discussing
are.
this, Gene did have a suggestion for
found
the
them.
cover letter that I thought worked.
Candace that I conflated on Friday. All right, well, I can
Steve,
talk.
go ahead.
Just since Jean's here, she had a suggestion for the cover letter that I thought was an easy accept. It was easy to accept.
Okay.
What was that?
Me too.
Yep.
Okay.
It,
Do you have that?
I'm sure I have an email.
It should be in your, are you?
Yeah, we have the
That's right,
package.
I'll look at the packet.
okay, do you have a
Your
text? Do you have a
Wi-Fi.
look at it? Okay.
Here.
They're supposed to be. Is it not picking up? I sometimes get.
I can't
terrible
open
reception
his,
in this room.
yeah, I can't get his. Can't
Dave
open
made a couple of comments.
password. Okay.
Dave made a couple of comments regarding interest in and knowledge of and compliance with law, and he referred to the fact that they are reflected in statistics at the end of the report. I think that that's fine. He also offered a few comments regarding the law school transparency clinics. Again, I think that those comments were well taken.
I had a question on that.
Yeah.
Are the clinics all restricted to students working in the courts? Or I wasn't sure about that.
Dave?
You know, that's a good point. I think some of them may be policy clinics, so maybe just take out the word courts and just say working in New York.
Okay, that would resolve that problem.
Would you have changed
And I
it?
think, Bob, someone should check with the Cornell dean. I know that Mark Jackson, the former general counsel at Dow Jones, is creating a clinic, but I don't know if they've publicly announced it. But I think they'd like to be included if it is known, and it would be worth a call to the dean's office.
So we'll call Cornell Dean. Okay. All right.
I have a few comments, attorney's fees. And again,
Okay.
I don't have Bob's and I don't have Dave's suggestions and I can't download them because we have no Wi-Fi in here. You didn't, okay, well, these are relatively minor. In the first paragraph, near the end, I'd put a period after statutory time because that sentence is just run on. Put a period, strike the and write an award of attorney's fees would be mandatory. So you're just
Okay.
breaking it into two.
Okay.
And then I want to sort of strengthen the topic sentence of the next paragraph and say the intent is not to penalize the government for incidental or inadvertent behavior. Because our intent is to penalize the government. So I think we have to qualify, and I'm not wedded to that particular language, but something like for incidental or inadvertent behavior, period. On the contrary, the goal is to encourage, and then I would put compliance with FOIL. So you're striking government to comply.
Sounds good to me.
And then add, after FOIL, add, and to discourage something like unlawful behavior, period. Oh, unlawful behavior, comma, thereby diminishing the likelihood of, and I would say litigation you don't need initiating due to a failure. So the sentence reads, the intent is not to penalize the government for incidental or inadvertent behavior. On the contrary, the goal is to encourage compliance with FOIL and to discourage unlawful behavior, thereby diminishing the need for or likelihood of litigation due to a failure to provide access in a manner consistent with law. We could probably shorten that more. It's wordy, but then in the next paragraph, I don't have this through the whole report. It's just here that it bothered me. As of this writing, and correct me if I'm wrong, the legislation has not yet gone to the governor.
That is true as of today.
Okay, has not yet gone to the governor for his approval, period. Because I think you're ambiguous when you say he hasn't determined. I realize he hasn't determined, and it'd be nice to know before it went to him. But I think as of this writing, legislation has not yet gone to the governor for his approval. The committee strongly, and then I would add this, supports this legislation, and urges its approval. Thereby, Lord, I can't read my handwriting, something bringing greater fairness to the relationship between the public, I just think brings greater fairness to the administration of justice. I don't think that's a good ending, but something. Because it really isn't the relationship, it isn't the fairness between the relationship. I don't know, but I think fix that first sentence and then let's figure it an end. The committee strongly supports this legislation and urges its approval. Period.
Just end the paragraph there.
Yeah, just end the paragraph there. Period.
Okay.
Franklin, you can break the paragraph above it by putting a period at foil, removing thereby diminishing and saying that would diminish.
And to discourage unlawful behavior.
Oh, I'm sorry, and period after behavior. But the next sentence would start then saying that would diminish.
Yeah, I think that's better. That's better.
Okay.
Sure, I have a lot of changes.
Well, now that we've gotten that all done, we can go home, right?
Yeah, I'm sorry. If I'd had it before last night, I would have sent it on. But that's the end of my comments, I think, on the first section.
All right. We move on to the legislative priority section. Where Dave suggested a stain on New York at the beginning. Bill suggested a statute in distress.
I like Bill's.
I like those.
Is that okay with you, Dave? A
I'm not
statute
sure
in distress.
I'm not sure the statute is in distress. Maybe a statute causing distress or something. I guess I'm not quite getting the reference. The statute is in distress? What does that mean? Maybe I'm just dense. It's just, to me, I don't understand what we're trying to say.
How about a statute,
Messed up.
a statute creating distress?
I just thought yours was too strong.
Agreed.
I just think it's time to, shout it out. I mean, we've been doing this is our fourth year in a row. And it really is. It's unique in the country, and it's uniquely horrible. And why not call it what it is?
Well, rather than the statute, a section that does not work.
It's
Or it
worse
does
than
not-
it doesn't work. It's causing affirmative harm to people's confidence in their government. It's not that it doesn't work, it's that it's causing harm. That's it.
Well, we all
A
agree. it needs to
harmful
be changed.
statute.
A which?
I like the stain.
What was the? Yeah.
A
I'm
harmful
not, I'm not
statute.
tied to a stain. It's just it does seem to me that we should be rather strident, and it's not just that it's sort of something that doesn't work. It's something that is
It's getting
affirmatively-
worse.
affirmatively creating problems.
And getting worse since we started
Maybe
writing
to say
about
something
it.
like a counterproductive statute or something, but
That's true, too.
Well, part of the problem is how it's been interpreted, right?
Yeah, that's
Right.
a huge problem.
Can we get that into the meaning here, or the title? Statute misinterpreted.
I had the purple pen out when I wrote this.
I like
carried away.
stain. I don't mind stain. I think
No,
it's
because it doesn't
gross.
describe the problem. It's descriptive of the frustration, but doesn't describe what the specific problem is.
I don't know. I like the word stain too, and I would say a growing stain because that's what it is.
Oh, I like that.
I like that
too. Got the red meat out, Bob.
A growing. Well,
No,
some people don't like stain. We need to come up with it.
It's a growing problem.
How about a growing problem, Steve? That's true too, and that covers stain. It covers distress. It covers both.
okay with that.
I like that.
What about just saying like a corrosive statute or something in need of reform?
I don't think that's better than stain.
You're going to make people happy with stain by the time you're done.
Are people accepting of a growing problem?
I'm okay with it.
Okay, let's
I
go with
prefer
the
growing
growing
stain,
problem.
actually.
Okay.
All right.
There were a couple of other suggestions here. I think, Dave, you added one to your own. A review of, in the first paragraph, after the second sentence, a review of its legislative history indicates.
That was mine.
That was Bill's. Okay, I'm sorry. That was Bill's. Yes, I have Bill's. which I think adds some context.
fine.
I think
Yes,
that that's,
I
I think
agree.
that that's fine. I think somebody added, I don't remember
You guys
who,
had a few.
Yeah,
Steve Waters
I
did.
moved the state and local police.
Yeah, state and local
and
police
got rid of
agencies.
the extra clause. Public, state, and local police agencies.
Yeah, that was fine.
Yeah.
There was a comment regarding the footnote, footnote 3, I believe by Bill, and it does look as though one case is saying one thing, the other is saying something else. And what I added, which I think is accurate, you have the Stewart case, which is an aberration. What you have in contrast is Capital Newspapers versus Burns, a Court of Appeals case. And Stewart was wrong in that it permitted deletion of names of officers from accrual and leave statements. Capital Newspapers dealt directly with that. The Court of Appeals unanimously held that those very same records were public. And so I just added a phrase, which I think will satisfy you, Bill. Stewart permitted the deletion of statements notwithstanding the Court of Appeals decision in Capital Newspapers versus Burns, which I think is accurate.
Yeah, I like that.
Okay.
We're missing a date for the case in footnote 8, I just noticed.
Footnote 8.
8 and 9 both are
Oh,
missing.
okay, we can do
They're
date.
not consistent either. You got New York Civil Liberties Union, NY versus New York. Just
Well,
the
they keep-
citations for 8 and 9 need to be cleaned up.
Okay. Date and citation.
You just call it NY Civil Liberties Union in one and New York Civil Liberties Union in the other. New York City Department of Police. They should just be consistent.
Okay. Citations.
And date, yeah.
Let's see what else we've got here on that section.
Paragraph, situation is on.
The situation has deteriorated so dramatically, and Bill deleted a phrase there, which I think was fine, so dramatically that citizens are relegated to reliance on the occasional leak by the whistleblower, instead of to begin to understand what is happening.
Yeah,
It's the same thing.
it's this, that's better.
You have it in some instances.
Begin to understand. Where are you talking about?
Oh, I struck some
It
stuff,
struck
but
the
I added stuff
phrase,
as
but
well.
added the
I
phrase.
just thought the way it was, it sounded
It's-
like it's
it's
in
not
every
all
single
citizens.
case, and I don't think that's
Right.
true.
I agree.
My wife kills me
That
when
was
I do
awkward.
that.
Okay, so what do we have? What's the sentence
The
there?
way I had it was the situation has deteriorated so dramatically that, in some instances,
Okay,
citizens
Citizens
are
are
relegated,
gotcha.
Yeah, that made sense to me.
Yeah.
Good.
and then the end of it to receive any important negative information
Concerning the importance of the police officer. Okay, I think that that's really good. All right. Continuing, the next comments that we have are from Dave. In even the CCRB paragraph, about two-thirds of the way through, again, it is only due to another leak that the public recently learned. I thought that was good.
It was good.
Yeah, agreed.
And had found that Officer Pantaleo, recently learned that, had found that Officer Pantaleo had used a chokehold in violation of NYPD policy. What do we have there? Oh, you added something, Dave.
Yeah.
The public may never have known what discipline was actually imposed without the leak.
Yes.
I thought that was a good addition also.
Okay, you changed that
Yeah.
language because it didn't seem to make sense.
Yeah, which, we will make it make sense.
Okay.
All right. You wrote in the last paragraph, in the "it is long time, past time," The third sentence, while police officers have, you said, a particular need for such protections instead of unique.
Yes, unique is a very specific word.
I thought the particular was better. And Bill suggested in the next sentence, moreover, the courts are already equipped to protect against improper cross-examination.
Yes.
Okay, and then the last sentence, regarding a police officer's behavior, admission on trial, period, the blanket denial of public access to information about police activity that Section 50A imposes is unnecessary.
That's good.
Yeah,
Yes.
I like breaking it up into two sentences.
Okay, good. Going to the end, the next paragraph, the corrosive absence, that's your corrosive, Dave. You put at the end of that paragraph, it is long past time to act, instead of at the beginning of the next paragraph. And outright repeal would serve as a positive step toward increasing transparency in law enforcement, period. Bill took out and is our preferred corrective.
I would like to leave that in and would want to know a sense of the committee, because I do think it's the preferred alternative.
Yes.
I'd rather have it out.
Me as well. I think every year we go through this,
Yeah.
don't we?
Yeah, we go through it every year.
That's the
You know, the
preferred
fact,
amendment.
the reality is that if we take it out, you have the next sentence beginning with alternatively. I think it's implicit that it's the preferred corrective.
Then why not say it?
Well, we're representing this
because
as
two
being the
members-
opinion of the whole committee.
Yeah, because
And
two
it's
members
not.
don't like it.
Come
How
on.
many
Ken.
members?
Oh, three.
I don't think
I like it.
I like it.
I like it.
Well, I think leaving it out is appropriate, because I feel like we're supporting. Look, if people were to propose repeal, that's supported, but also I don't think that just a straight repeal is the only thing we're suggesting here. I think it's something that the legislature could do hearings on and could craft something that's, that they find an appropriate balance, but that serves the interests of transparency. And so, I don't know at this time that it's preferred, because we don't know the universe of what amendments could be made that could improve something or make it, serve transparency, but also serve other interests that are beyond the scope of what we consider when we look at these things.
Well, I wonder if
law
alternatively
enforcement.
isn't a problem. It seems to me that what we're saying is at the very least,
Yes.
rather than alternatively.
Yes, I think so.
I think that's a good
Yeah,
suggestion.
I think I like that too. Yeah,
Okay.
that's a good compromise.
All right, that's our compromise. So,
Great.
and our preferred corrective is out, and alternatively is out, and we've got at the very least 50A. At the very least.
Okay.
Find a new way
Good.
to resolve this next year.
We move on to food for thought.
Food for thought.
Where again both Dave and Bill have made a couple of suggestions. Right in the very first paragraph, Dave's suggestion would read as follows: last year's report encouraged thought and recommendations relating to changes brought by technology.
And solicited recommendations.
Yes, and where do I? Yes, I have and solicited recommendations. What do I have? This request reflected the reality that data is routinely maintained electronically, and that agencies can, Bill recommended, retrieve, which I think is find volumes of material quickly and easily. This kind of advance. I think those are all good suggestions.
Can I throw a wrench in the works?
Sure.
I think you can take out a lot of what's this, is this word really necessary? Removing that entry referred to this request, or this request reflected the reality that, and just to say, data is now routinely maintained.
Okay. Capital
it.
D, data.
Data are.
You're right.
Ooh.
Modernist or antique, one or the other.
Well, I think it's antique, yes. Those who know Latin would say data are. Steve raised a question regarding the intra-agency exception, which we discussed prior to the meeting, so I think that that's been pretty much taken care of. We move on where we're talking. I have the quote for the Court of Appeals case, which is an accurate quote.
Wait a minute, where are you? Okay.
I cite, there's an indent there for the Gould decision,
Jade.
Court of Appeals.
Where,
Oh,
Next page.
yes, Gould.
Okay, and would it be harmful? I believe that Bill suggested that should be expanded.
Can we go back to the quote? That's an accurate quote?
Yes.
Does it make sense to you?
Isn't it?
I don't know, but I agree with Bill that it doesn't make sense. It
Which-
feels like,
which-
it seems like
what-
can
what-
be discerned from the
Oh,
purpose. That's
Yeah,
the
from, I
purpose.
guess.
That, I don't know.
Yes.
I'll check
Something's
it.
wrong.
yeah,
So it comes down to,
all right,
I
we'll
will
check
it
the
for you.
quote. We'll check the quote.
I will read it.
I thought I went over it and it looked good, but I just might have missed the from. At the end of that, would it be harmful paragraph? The suggestion was that be expanded in some way to make it clear. And what I drafted,
Rhetorical questions. This seems like one of Bob's.
would it be easier to disclose the entirety of a communication rather than redacting the suggestion? Probably so. And then to clarify, tell me if you like this. There may be a series of communications relating to a particular topic that may be withheld, but they may relate to a public discussion by a board or a news media report that renders disclosure of those communications to be innocuous. And again, that relates to the notion of proactive disclosure where we can withhold, but does it really make sense to do so? And that would just be an example of a situation where an agency might choose to disclose because it does make sense to do so.
I think my comment went a little deeper than that. I mean, it starts off with the voluminous request concept, right?
Yeah.
But then we go into the federal statute. And I don't think the federal statute helps the voluminous request problem.
It doesn't really.
No. So I just thought that we weren't really making a point as we went down through this section. I mean, maybe they should be separate. Maybe they should be separated if you want to discuss both of them. We never really say how we're going to address the voluminous requesting. Last year we said we'd look into it.
Yeah, we
Now we're
did.
saying-
Yeah,
Yeah.
and we did, and nobody recommended anything.
It's
Bob,
really
can we go back to
difficult.
your, can we go back to your proposed addition at the end of that paragraph?
Yeah.
The innocuous, because I think you're headed in the right direction, but I think it's still ambiguous that the thought that we want to say is not that it's innocuous. It's innocuous, it should be permitted under the exemption because disclosure of information that's largely publicly known has been made publicly known by the agency in the past, means that the disclosure of the email is not going to have any significant impact on the quality of deliberations or future deliberations, which is what the exemption is supposed to do. You know what I mean? The word innocuous just doesn't capture. In other words, this exemption allows agencies to withhold information to protect their ability to have frank discussions. And if things are already known, disclosing the email isn't going to have any impact on future discussions or deliberations. It just deprives the public of context.
That's what I tried to say, but you expressed it better. So the notion is not to suggest that it's innocuous, but that it doesn't harm the deliberative process.
Right.
Yeah, would have no harm on, yeah, which after all is what the exemption is meant to protect.
Good point.
And I think this does go to some extent to the notion of the voluminous request. You know, if somebody says, give me all the email communications for the past 5 years between X and Y, well, the ones from 4 years ago are indeed, in most instances or in many instances, innocuous, not to use that word again. And where agencies could just dispense with review, I know that it's a suggestion.
We're ever gonna dispense with review.
Well, that's because you have this governor, you know, we'll see what the next governor
We're
does.
still gonna have to look at it.
Maybe. But you may look, but you may not have to redact to the extent that you do.
That doesn't really save that much time. It's the review that takes all the time.
Bob and I had this conversation too, so.
I don't know.
Let's see how you put it all together.
Yeah, let's see how we put it all together with the deliberative process part, which I think is really,
I suspect if we really want to get into this, I don't think we should try to do it in this report, but it may be next year. That the Department of Justice has been struggling with this whole issue in light of the amendments that you referenced. And they had adopted some internal regulations to guide people about when you shouldn't claim an exemption, an intra-agency exemption. It has to do with how old are the documents, do they relate to a decision that hasn't been made yet or that's already been made? Does the information that's disclosed really involve a deliberation, or are you just protecting kind of illegitimate discussions and content?
you know, as I suggested, somebody reviews it, and what if the agency continues to deny access, and the applicant says, well, wait a minute, this is years old, and it really doesn't involve deliberation. You go to court all over again. Yeah, I don't know that it's a great solution. I think it's guidance.
So it is guidance. It is guidance, but you know, it's guidance to push the courts in the right direction too. So
well, that's why I said, you know, it's something that we should emphasize, and we do, is pushing agencies to look carefully at the record and say, wait a minute, does this really reflect something that would be harmful? If not, let's disclose.
exactly.
Okay.
And that's what the Department of Justice guidelines are for. They're for the agencies to use in deciding whether to withhold. So I just think we might look at them and borrow from them in the future.
Okay. All right, so we'll work this out, and
Typo on Dave's added sentence at the very end of it.
was there a typo? Which sentence?
We also.
Where are we?
Intent.
I think it's.
You mean intended, right?
Oh, yeah.
We're still on the would it be harmful?
Yeah,
paragraph.
intended instead of entered.
Subsection.
I don't know where
Yep.
Page 9 at the beginning.
Top.
Dave's.
Oh, intend, yeah, I put that intend also.
Wait a minute. Where are we? We're before the quote.
It's in the red. And we intend them on it.
Okay. Oh, I just back. This is tiny, but the paragraph that begins, Congress recently amended the Federal Freedom of Information Act. After 2016, let's put in a citation. And I also felt like, just for those not in the know, and the same as we go into the partial disclosure, you've got two aspects of the amendment are already found in New York FOIL. Either in that paragraph or the next one, let's add another citation just so people can find it if they're looking quickly or want to look to what the two amendments are.
So, I don't know where you're thinking about.
Oh, what used to be B, partial disclosure enhanced through technology. Wait a minute, now I've lost it. Yeah. Where,
Page 9.
page 9, where we go two other aspects of the amendment already in New York law. I just think we ought to have a citation either there or in the next paragraph where you actually discuss what the two are. Just somewhere in
Yeah,
there.
well, we have citations for
Where?
In the for several years paragraph, FOIL is stated. When an
Yeah, I
agency
just
has-
would. Yeah, I just would put it up in one of the early. Are both of them
reference.
in 89.3? Oh, in 89.9. I think I'd put it up in the
Yeah,
setup
it should be at the
paragraph.
first reference.
Yeah.
Where are we?
I'd add a cite after two aspects.
Should be.
Two other
First
aspects of the
citation.
amendment to the federal FOIA are already found in New York FOIA.
Disclosure.
Or put two other aspects of the amendment to federal FOIA, comma, blank USC blank, are already found in New York FOIA.
I don't have partial disclosure.
You don't have partial disclosure.
Page 9.
Yes, you do.
Yeah,
Aspects.
Yes, it's up here.
Oh, I see it.
the very first
what
sentence.
do we
under
say
the
There
there?
we
heading.
are.
It's just that the citation that's here ought to be initially mentioned up here.
Okay. Thank you.
Section 89 generic license.
So you could
Yes.
put two other aspects of the amendment to federal FOIA, comma, citation, are
Okay.
already found in New York FOIA, or put it at the end of the sentence, just somewhere. C blank, USC blank, or whatever.
Okay, so we need citations there.
Earlier paragraph.
We do have it. I don't think we have
That
this.
should be up on page 8.
Okay.
Well, Dave is saying it should be up earlier, where we first talked about it.
Right, on page 8. Congress
Right, you
recently
mentioned that on page 8.
Employee Improvements Act.
first mentioned there.
USC. blah, blah,
Yeah.
We'll put it in both.
Okay, yes, I agree.
I have
Oh, and
citations.
you know what? I have it written there. I just
blah. I thought
lost
you
it.
did, you mentioned it earlier.
Yeah. So we're going to add a
Okay.
citation earlier. But I think it doesn't hurt when you get to the two provisions that are already in New York law to repeat the citation with those specific aspects of the amendment.
Without objection.
That's fine.
Got that?
Only citation. Okay.
Too many lawyers in the room.
Yeah, I know.
All right.
You too many briefs.
I think the only other significant element of this involves the section dealing with algorithmic decision-making. And Dave added a paragraph.
That's the problem.
Yeah, here, you should look at this. This was,
Yeah, I've been following this.
Dave made a few changes there, which since I don't know anything about algorithmic decision-making, I'm willing to accept them at face value.
I like that. I can read it in the text here. Your changes didn't pop up as changes. They popped up as accepted changes in my version.
Everybody see the proposed changes that Dave suggested? They just put this in perspective and indicate more about what algorithmic decision-making is.
You know, if you want, Bob, too, I could give you a cite to the court case where that whole thing came up to put in. It's people against somebody in
I think
New
that
York,
would be good.
New York County.
Okay,
But it
if you
was
could,
just-
if you could send the citation, that would be great.
I
What
will
was
do
the
that when I get back to my office.
situation in that case?
It was a criminal prosecution in federal court where the defense lawyer subpoenaed the CME
Oh, this is
software.
the DNA thing, the same thing.
DNA,
Oh, okay.
but it also relates to FOIA because up until that case, which was just resolved like 2 months ago, the Office of Medical Examiner would refuse to produce this under FOIAs too, claiming a trade secret exemption. So that's the point of including it here is that we can't have government claiming trade secrets on things that are vital to understanding how government's functioning, like how voting machines work or how DNA is tested. Those are just so basic to democracy that there has to be some sort of transparency.
I had suggested in the previous paragraph putting in what the algorithm is, which speaks to the same issue. That in any subroutine, you don't want to have magic.
Yeah. No, I thought your additions were good.
what's I'm not that familiar with it. But what's the harm? Is there a harm that they claim? Like, do they argue there should be just in-camera review
They
or
claim
something
that it's
of
a
the
trade
algorithm?
secret and nobody should see it. You know, the fight in the court case was we're not going to let the defense lawyer see it to challenge. It says, you know,
People can
we
rip
matched
off
the
the
DNA and you have to accept our word that we matched it, and we're not going to let you know the software. And in DNA in particular, it's problematic because the way they match it is through these probabilistic things. You know, they take very small amounts of DNA that's mixed with a lot of people's DNA, and they create probabilities that it came from any one person. But they didn't want to disclose the math they were using to decide whether it was valid.
I have that in mind.
The government have trade secrets?
Well,
I
that's
get
not a
it.
good question.
Yeah, I was wondering that too.
We're not sure the government has trade secrets.
Yeah, is it something the government owned or is it a corporation?
Well, there is case law which indicates
Contract
the
with-
government might have trade secrets.
Oh, yes.
Yeah. And the problem exists even if they go to a private company and buy their software, and then they say, well, we're not going to tell you. So,
Right.
you know, there's really good, there's certain things that are going to have to be open source software if we're going to be able to function. So,
I mean, in this case, it makes sense to me, what you're saying, but might there be, I know this is separate from trade secret, might there be IT security issues in releasing certain algorithms? Again, in this case, it makes sense to me what you're saying, but not having my strength be in technology, I just don't know the full, breadth, I guess, of where algorithms may be used.
Yeah, I was thinking the
But
same
I think
thing.
but we are focused on discussing it as a trade secret here.
no, those are really valid concerns, and there is an exemption now in New York law that says that critical infrastructure, which of course have construed to mean software too, can be withheld. And all we're saying here is that this is an area we need to monitor and think about. You know,
I think
like
that's
if
fine.
you had a black box voting machine, which some states went to, that you go in and you push a button and you leave, and you have no ability to there's no paper trail, and you have no ability to know what the machine's doing. How can that be a system people will accept? You know, so it's just an area, and it's going to become a larger and larger issue because more and more government functions are going to be turned over to computer programs to sort out. You know, who's entitled to welfare benefits? Who's entitled to, you know, special parole? There's software now that tell judges what the bail levels should be. And if none of that is open to investigation, you know, we become just a black box. Government becomes a black box.
I agree.
And
You know, when
this
you mentioned it,
paragraph-
I tried to do a little research regarding algorithmic decision making, and I'm guessing that it goes on all the time, and we have no idea that that's happening. Where the machine, the computer, when fed with various elements of data, will come up with a conclusion. And the article that I read suggested that we should know what elements are used, who makes those decisions, what is the weight that is accorded certain items that go into the outcome using the algorithm. There are a zillion issues there. I think you're right, Dave.
Doesn't the IRS use something like that to decide what returns to audit?
Sure.
I mean, on a relevant issue basis.
Yeah. There was a famous case in the Obama administration, I think it goes back now about 6 or 7 years, where the State Department issued 30,000 green cards using an algorithm and then realized they had made a mistake and they had to write 30,000 people who thought they were being admitted to the United States and say, oh, never mind, and it created a big uproar. And then they wouldn't disclose the source of the problem, which is what led to a lot of people to start focusing on this. So.
Pretty interesting.
Good.
All right, so there was only one other item that I could see, and Dave picked up on it, referring to the former chief judge instead of the chief judge.
Where is this?
This is
Cameras in the back.
toward the end.
The last page.
I actually had a clarification.
Just before the
Okay.
list of services.
Yeah, before the list of services as Chief Judge Lippman expressed, as former Chief Judge Lippman expressed.
Yeah. Back on page, or at least on my draft, page 10, technical amendments. You've got the following proposed technical amendments reflect an effort to clarify existing provision. And then you've got a for instance, but I think really it's first, second, and third first, there are two provisions of FOIL that state. Second is the recommendation, and finally is the third. And I just think the for instance was not clear to me. Aren't there three things that we're focusing the reader on? The
So you
following
were
proposed-
first, that
I'm
there are
right
two
under
provisions.
technical amendments.
Very first sentence.
Yep.
The first sentence is fine, but then you've got for instance. Isn't that really first,
Yeah.
as
I
opposed
gotcha.
to for instance? And then I don't care whether we put second or also included.
Well, I
and
think
finally or
it's
third.
important to put second and third because each one is significant in its own. It's not a demonstrative example.
Okay,
Okay,
I
I
thought
think
they were
that's-
kind of smeared. So let's first, second, third.
Good suggestion. Anything else?
I just had one thought, which probably doesn't make sense, but since we have essentially a whole new Court of Appeals, I wondered if it would make any sense to move up the cameras in the courtroom as a higher on our list, just to see if it gets any nibbles from them. I have no idea what the current chief judge thinks about this, and whether they would be willing to make a push for it.
More important than a new Court of Appeals, I think, is a new speaker. I mean, Silver seems to. Sil-
That's a good
Silver
point.
was the primary stumbling block. I have no idea how what the new speaker thinks
Maybe
about it.
next year.
But
maybe
certainly
next year-
we could move it up if you want.
Yeah, I think maybe next year we should have a section like we did years ago on 50A, where we just had an informational section. An informational section on cameras in the courts, and collect some data about what's going on in other states, where I think we're still one of only 2 or 3 that doesn't allow it, and try to draw some
Definitely.
attention to the issue again.
Definitely behind the times, but I think we can move it up and focus a little bit more attention on it.
I had just a few words to add to the. I'm on under reasonable use of cameras in courtrooms. While several judges have determined that the statutory ban on the use of cameras is unconstitutional, legislation remains necessary, to ensure that court proceedings are truly open to the public.
Okay.
Maybe instead of truly, could I offer an amendment and say meaningfully open?
Meaningfully open. That's fine with me. Just think it's a little more specific. And we skimmed up. I hate to go back again, but disclosure or withhold E911 records pursuant to FOIL. It used to be called C, but I'm not sure if it's still C. Let's see.
Yeah, it is.
I found that confusing. I just think the issue can be set up better. You've got a reference to county law in the second paragraph, but it's not really cited until the third paragraph. I just think there's a better setup. We kind of jump around a little bit. And it's not clear what's being repealed. I'll work on it and send some suggestions.
I could just quote the statute.
I just thought it was unclear exactly what the section says and why we were unhappy with it and why we suggest repeal. And I think it was the first 2 paragraphs that gave me a problem with the setup.
Okay, so we need to clarify and I think cite the language of 3084.
Yeah. And then indeed, this is just a comment. For clarity, timeliness, and economy, we believe that FOIL should be amended to require the state legislature. Isn't it more than clarity, timeliness, and economy? Isn't it fairness? Isn't it? When we're saying the state legislature should be subject to the requirements of FOIL, right?
Yeah.
I think it's more than clarity, timeliness, and economy. Seemed to me it's, I don't know, fairness maybe isn't the right word, but
For accountability and transparency.
accountability and transparency. I just think it's more than a matter of economy and efficiency. It goes to the heart of what we want, which is transparency in government. So I would just have a stronger statement, or one that at least,
Well, I would add accountability, transparency, and trust.
like that.
I like that.
Should we start off that paragraph with to promote, to guarantee?
Promote.
And-
No guarantees for the legislature.
No guarantees.
To promote accountability, transparency, and trust, the committee believes.
Okay.
Or urges that FOIL should be amended. I mean, do we want to go beyond belief?
Yeah. I like urges.
Urges.
Yeah, it's not gonna happen.
It's not going to happen. This is what the governor has been pushing, and the reality that is that the legislature is covered by FOIL, but differently. And in fact, the assembly has rules which by and large reflect FOIL as it applies to the rest of government. How well or poorly they abide by those rules, I don't really know.
Well, if it's already covered, they should have no problem, right?
Right,
And they can change their rules anytime they want.
right. It's inconvenient. Okay,
Good work.
all right, I think
11
that's
on
the
the
end
dot.
of my comments.
So, anybody else for more comments?
We want to get Dave out on time.
Dave, it's 2 minutes past 11.
I know.
You're late.
So-
You're late.
We're doing great. We're doing great.
So the
Well,
main,
can we-
the main
can we
change
have-
we have is a little bit of a stronger opening statement, which I'm happy to work on. Do we need to meet again? Can we
I hope we
circulate
don't
a?
need to meet again. You know, what I would do is suggest that those who are going to submit something, which are relatively minimal, get it to us within the next couple of days, if you can do that, and we'll send out a draft, and if there's no objection, we'll consider it done. And we've done that in the past. Is that okay with people?
Yes.
That's okay.
Sure.
Okay. I saw a nod of the head. Yes. I saw
no.
I saw a minimal nod.
Reserve for the race.
Yes. We're good. We're good.